Hello, friends, welcome to my channel. Today we will look at the doctrine of Estoppel. Estoppel, in literal sense, means prevented from denying. Estoppel is a legal doctrine where the courts have found against people or entities who have acted unfairly by misrepresentation or by not keeping their promise. In simple word, it means that once you acted or did something relying on a statement or promise made by the other person and later suffer an injury or damage as a result of that reliance, the defense of estoppel will come to your rescue and will bar or stop the other person from denying what had happened. For example, if Mr. X asked Mr. Y to buy a piece of land which belonged to someone else, and believing on Mr. X's promise, Mr. Y buys the property, then the doctrine of estoppel will be available as a defense to Mr. Y and will prevent losses accruing to Mr. Y as a result of false misrepresentation by Mr. X. Estoppel applies to written and legally binding contracts, but also to verbal and unwritten contracts or promises. Friends, estoppel is a legal principle under which the court can prevent a person or a legal entity from going back on their words, which the court has held to be true. There are mainly four types of estoppel, but before we get into them, there is a common thread that runs between all of them, and that is a few principles that are common in all of them. Number one, an established relationship exists between the parties. Second, there has to be a clear and unambiguous communication between the parties. It is not necessary that the communication is direct, it could also be an indirect communication. One party, that is the defendant, wanted or intended the other party, that is claimants, to rely on their representation, promise, or words. The claimant's decision was influenced to a certain degree by the representation or promise of the defendants. The claimants suffered losses as a result of relying on that representation, and the respondents denied that representation. So, in summary, there has to be a promise or assurance. Number two, a reliance on that promise. And number three, it should result in a damage to the claimants. Estoppel in these circumstances will prevent any person or entity from going back on such a promise, and estoppel as a defense will come to the rescue of claimants. Now, friends, there are mainly four types of estoppel. There are many more, but these are most commonly used. Number one, promissory estoppel. This kind of estoppel is used in contractual relationship. It means once there is a contract wherein a promise has been made and the other party acts on that promise, then the first party cannot go back on that promise. The doctrine of estoppel would apply in this situation. Second is equitable estoppel. Now, equitable means anything that is just or fair. This estoppel protects the other party, that is claimant, from the unfair or inequitable conduct of the other party, that is the respondents or the promisor here. Third is estoppel by deed. This is very popular in real estate. A person who is selling a piece of property, land, house, apartment, etc., cannot deny the accuracy of facts which are provided in the deed. And number four, estoppel by convention. Now, convention means that if two parties have behaved in a certain manner for over a period of time, it can be presumed that they would continue doing so in the same manner in future as well. Then it is said that they are bound by a convention. And if any party digresses from the same, estoppel by convention will come to the defense of the claimants. So friends, I hope this video made this topic of estoppel simple and easy for you to understand. Thank you so much for your time. I hope you liked the video, and I'll see you soon with another video. Till then, goodbye, take care, and have a great day.